Hi everybody, just a quick announcement before we get going. We have quite a few people joining today, so I'm just going to give it a minute or two just to let everybody get into the Zoom room and get settled down. We'll be underway very shortly. Hi everybody, and a very good morning to you from the team here at the K3 Hub, and welcome to this morning's structured CPD session. For those who haven't virtually met me before, my name's Marie, and I am a Managing Director at Quantuma. And on behalf of our parent company, the K3 Capital Group Limited, I lead the K3 Hub, which is a member network for professional advisors developed by us and other companies within the K3 Capital Group. By way of a bit of background for you, for those people who are newcomers today, the K3 Hub launched in the spring of 2021, and we're proud to have over 2,750 members. The K3 Hub offers a range of CPD and training sessions, not dissimilar to today's event. We also offer referral fees for certain types of work referred into our group. Now, it often occurs to me that I don't always tell you what the K3 Capital Group do, so I think I'm just going to take just a few seconds to do that. So we offer a range of niche advisory services, including restructuring, corporate finance, forensic accounting, R&D tax credits, and marketing services for professional service firms. We offer those to a range of accountants, lawyers, lenders, and also the businesses. A few bits of housekeeping for today's session. So we are recording today's session, and the webinar will be on the K3 Hub website next week. Q&A function is open, so do feel free to ask questions as we go along. If you do have questions, we would appreciate it if you could use a Q&A so that Toni, our speaker today, knows where she's looking for your questions rather than the chat. So I can see that there are, oh, sorry, I'm going a bit fast, I think. So I can see that the chat is open, and that sometimes we do get questions in there. And if you do have questions for our speaker, if you could go through Q&A, that would be great. I think Toni's preference is that she'll look through those at the break time, unless there's something that's pertinent that pops up, and she'll kind of, cover that straight away. We will post the slide presentation into the chat at the beginning of the session and at various points through the session for latecomers. We are aware that today is a long session, it's 3 hours, so we are going to take a couple of comfort breaks, which are likely to be there or thereabouts on the hour. We have got a few poll questions today, and they'll be run throughout the session. I think there's about 4 of them in total. Now, just to welcome our speaker, Toni. So this is Toni's second session with us this year. Toni is a qualified HR practitioner, mediator, trainer, and coach. She has an in-depth understanding of grievances, disciplinary hearings and appeals. She hears cases for the tribunal, employment tribunal judiciary, and she's worked for both large and small companies in HR and employee relation roles. So a little bit about today's session and what Toni will cover. A roundup of recent legislative developments, recruitment and interviewing, contracts of employment, bullying, discrimination and harassment, disciplinary procedures and grievances, and managing fair dismissals, including redundancy. Just before I hand over to Toni, I just wanted to flag the next CPD session that we have for you. That will be running on Friday, the 3rd of November, and we'll be welcoming back our very popular speaker, Malcolm Greenbaum, who will run a corporate tax update. If you look out for your invitations, they'll be going out next week, and keep your eyes peeled on the inbox. We've got another session running towards the back end of November as well. In fact, no, it's the back end of this month. And also we have an autumn statement briefing to follow. So do watch your inboxes. There's a lot going on in the K3 Hub. That's about it for me. Thank you very much for joining us this morning. And I'm going to hand you over to Toni now.
Thank you so much, and thank you for that lovely introduction. So welcome to our session this morning. I'm really pleased to have been asked to speak again. Let's go through what we're going to cover in a little bit more detail. Just firstly, for those of you that haven't met me before, my name, as Marie said, is Toni Trevett, and I work for a small consultancy called Complete HR Limited. And I also sit and hear cases part-time for the Employment Tribunal Service, which is the part of our judiciary that deals with discrimination cases, unfair dismissal, breach of contract, all those kind of things. And I'm glad they don't do long service awards, because I've just passed my 30th year, which seems like a very long time. Must have been child appointed. And we do far more online than we've ever done before. Obviously, the pandemic sped that up. And they're called cloud video platform hearings. So just like this, people dial in. Obviously, everybody has to have their camera on, and there's typically, between 6 and 15 people, depending on how many barristers and solicitors there are. But that comes with a whole raft of difficulties sometimes, with Wi-Fi dropping in and out and noise in the background, and people trying to dial in and read 300-page bundles on a mobile phone. But it also has many funny moments as well. And I'm starting to collect the ones that I'm involved with, just for prosperity. And I've got a top 3, which I thought I'd quickly share with you before we get into the detail of what we're covering today. So my first one is called The Naked Boyfriend. And I think from the title, you're going to have a good idea of what happened on this hearing. So a person was giving evidence, being cross-examined at the time. And behind them, we see a door open, and this person's boyfriend walks out totally naked with his head in a towel, drying his hair. He's just stepped out of a shower. And collectively, all 12 people shouted, "Turn off your camera." So that was quite an entertaining intermission to that hearing. And then I've got one called McDonald's Delivery. And this is a candidate giving evidence again, which is all very serious. And right in the middle, doorbell rings, they jump up, they don't ask to be excused, they jump up, open their front door, take delivery of their lunch, come back, put on their headset, and then say, "Would you mind if we finish early for lunch? Because there's nothing worse than a cold hamburger." So it's lovely to see how people relax into these kind of hearings. And then my last one, which is my favourite, is levitating paperwork. So when someone gives evidence, it's very important that they give their own evidence, that they're not prompted or coached or, coerced to saying anything in particular. And this person's talking away, and every so often you'd see sort of some paperwork seemingly just appear. And then finally we saw the hand come in and the document arrive. So stopped the hearing and said, "Who's in the room with you? You've got to give your own evidence." To which this person thought their best option might be to lie and say, no, there's no one else in the room. But it was very obvious that there was someone else, and this person didn't have 3 or 4 arms. And in the end, it was a young man giving evidence. His mother kind of popped up from between his legs under the table and said, "Oh my goodness, it's me. I'm so sorry. I'm just helping him. He's very young. He's never done this before." So that was a little bit entertaining as well. It's not disappointing when it goes to plan, but sometimes these funny moments are good to remember. I hope I haven't spoilt the next 3 hours by jinxing this session. But there you go. I'm going to continue to collect them and see what else happens. Let's go on and look at Marie very carefully and quite rightly introduced what we're going to do. I think there's probably not much more I can add to that, other than we'll start with what we've already got, and then we'll end with what's on its way. And there's quite a lot of change coming up into next year now, so we'll give a bit of time to that at the very end. Okay, so let's start with 2022, and we'll go in date order because I think it will just be easier. So on the 1st of July 2022, the Fit Note certification rules changed. And as I'm sure you're aware, a Fit Note is the official statement from a registered healthcare professional giving their medical opinion on a person's fitness for work. And Fit Notes used to be called Sick Notes. And from that date, 1st of July 2022, the range of people that can complete a Fit Note was greatly expanded. So now we find that nurses and occupational therapists, pharmacists, physiotherapists, people like that working in GP practices or in hospitals are now able to prepare and sign a Fit Note. And that change followed on from the digitalisation of Fit Notes, which was a couple of months earlier on the 6th of April last year. And all of this is intended to free up GP time for consultations and streamline the process for patients, employers and the NHS. And if you have questions on Fit Notes, ACAS have some great guidance that I think is really useful, if that's something of interest to you. So we've got a question. How many days off must be taken as sick before a Fit Note can be requested? And it's a poll question. So I think the poll has appeared. I can see it, so hopefully you can. See what you think. Pick a number. Okay, so here's the response. Thank you very much for participating. So we've got most people thinking it's 5. 17% think it's a working week, because that may change for different people. 31% say 7 and 4% say 8. Well, interesting. So if someone is off sick for 7 calendar days or less, including weekends, they don't need a Fit Note. So it must be that a Fit Note is required from the 8th day. So if it's 7 calendar days or less than 7, they can tell their employer that they're not well enough to work. They don't need to provide medical evidence. And this is called self-certification. And some employers have forms that they ask people to complete so they've got a record. It doesn't affect sick pay, because you still get whatever sick pay you're entitled to, contractual or statutory sick pay. However, if the employee is off sick for more than 7 calendar days, that's when they should get a Fit Note from one of those registered healthcare professionals that I just mentioned to you. And this is the case even if the employee was not supposed to be at work for some of those 7 calendar days. So if some of those days are weekends, it doesn't matter. It's calendar days, not working days. And healthcare professionals can give a Fit Note by email as well as by a printed copy. And the employee should give the Fit Note to their employer when it's provided to them. If there's a delay, then the employee is supposed to contact their employer to explain why there's a delay, and then get their Fit Note as quickly as possible afterwards. And you can indicate on a Fit Note, or you'll see indicated on a Fit Note, whether someone is classed as not fit for work at all, or whether their second category is relevant, which says they might be fit for work. And if they tick the might be fit, then they will explain in what way that person would be able to work. And often it limits types of work, or it includes a phased return or some sort of rehabilitation to get someone back into work. So it is after the 7th day that you need a Fit Note. And here's another question for you. An employee can return to work before their Fit Note has run out without your permission if they want to. So is that factually true or false? Someone can just come back to work when they feel like it, even if that's before their Fit Note has run out and they don't need their employer's permission. So all you need to pick is true or false. love the way it says the host can't answer the question. There we go. So true, the lesser number, 42%, false is 58%. And you're going to be surprised, maybe, or 58% of you might be surprised to hear that actually it is true. Someone can return to work without sooner than their fit note expires. Obviously, they need to make sure that they're well enough to return to work. So there's nothing stopping someone from talking to their doctor about this. And if the employer has concerns, then they can talk to the employee to make sure that they're not putting their health at risk by returning early. But what often happens is someone is signed off maybe for quite a lengthy period, and that's maybe the GP's best estimate of how long it might take you to recover, but recovery could be quicker. So there could quite genuinely be reasons why someone would be able to come back to work earlier. And especially if people are paid SSP only, they obviously will want a preference to get back to work and full pay as soon as they can. And there may also be rehabilitation that can be agreed, or a phased return to work when someone comes back as well. But generally, the employee can choose when they return to work. Now, remember, if someone is off for a back injury, or their job involves heavy lifting, even if they say, I'm okay to come back, you may, with your duty of care, think, okay, we're going to make some adaptations, some light duties for at least a short period of time. And the fit note might also say that. It might say when able to return to work, these are the phased changes, or the way this person should be reintroduced back to work. I'm often also asked whether a fit note is binding on an employer. And the answer to that is no. And it's very clearly a no, because the guidelines issued alongside the fit notes clearly say that a fit note is for an employer's advice. So the assessment is about whether the employee is not fit for work or maybe fit for some work. And it's actually for the final determination is for the employer to determine whether or not to accept that. And if it says fit to work or fit for some work, and the employer is unable to accommodate that person, let's say they need some changes, some light duties, then if an employer can't accommodate that, then it is as if the not fit for any work box had been signed, and that person would stay off work. And occasionally you might be in a situation where your employee is not fit for work, even though they've been assessed as being fit. And so you might want them to see an occupational health specialist to get some more information. And you might choose to give precedence to the occupational health specialist's view over that person's GP or healthcare practitioner, because often OH specialists have a much better idea of the type of work that people do. So it's quite interesting how the fit notes work in conjunction with occupational health and an employer's opinion. But if in doubt, have a look at the guidance. They're really, really helpful. Okay, we're going to move on to the next bit of legislation that we had. So hopefully the slide gives you an idea. This was on the 21st of July, when we had the ability for agency staff to replace employees on strike, and that became lawful for the first time. So on that date, the Conduct of Employment Agencies and Employment Businesses Amendment Regulations, that rolls off the tongue, came into force. And that allowed employers for the first time to use outside agency staff to carry out the work, to replace the work of employees on strike. However, it might surprise you to hear that the unions weren't particularly happy with this legislation, because the whole point is that no one's doing the work, and that causes the difficulty. Not that an employer can just phone up an agency and just replace everybody. And remember, people aren't paid when they're on strike. Their union may well pay them, but they're not paid by their employer. So, yeah, the trade union's not happy with this legislation, and soon after, they raised a complaint and went to the High Court and asked for permission to have this legislation reviewed. And the TUC, the Trade Union Congress, on behalf of 11 trade unions and Unison, launched this judicial review of this legislation. And to bring you up to date, that court case was heard, and it resulted in the regulations being entirely repealed or quashed. And on the 13th of July, that case was heard. So from the 10th of August, it was therefore again unlawful to replace striking employees with agency workers. So it was only law for a very short period of time. Of course, an employer can still replace people on strike by using, its own employed temporary staff, bank staff. It can move employees internally to cover essential jobs. I don't know if you remember the big corn factory strike last year, where they went out on strike. I think it was for 11 weeks or maybe even longer. And they deployed all their managers to keep production going during that strike. So there's nothing stopping an employer from redeploying its own staff to cover those jobs, or of course using volunteers from bank staff to come in, but it just can't use agency staff. That new legislation also brought about a significant increase to the maximum damages that can be awarded against a trade union if they take unlawful industrial action. So there's lots of steps when a group of people want to go on strike. There's lots of steps that the union is responsible for ensuring are taking, and appropriate balloting, for example, is one of those essential steps. So if they fall foul of the process and the strike ends up being deemed unlawful, then there can be substantial fines, and that's what this legislation changed. And it said if there's unlawful industrial action, then the union may be liable to pay damages of £1 million is the new amount. It was 250,000 and it's gone up to £1 million. So quite a bit of change to trade union legislation we've seen, which really is a result of the increase in strike days. I think last December, there were more strike days than they'd been in any other month for 10 years. So there's been, I'm sure some of you may have been affected by this yourself. Okay, moving forward a bit more, 5th of December 2022, we saw an extension on the ban on exclusivity clauses coming into 0 hours contracts. So this means exclusivity clauses, and remember those clauses are the ones that are intended to prevent employees from working for another employer. So they restrict exclusivity to that particular contract, that particular employer. So from the 5th of December, and that became unlawful in 0 hours contracts for anyone above or below now the lower earnings limit, which is £123 a week. So we already had exclusivity clauses on those above that level, and this extended it to those below that level. And 0 hours contracts, as I'm sure you're probably familiar with already, are a very flexible option for employers and workers for that matter. So if the work is not constant, it's ad hoc, it's as and when, then this works because an employer does not have to give any minimum working hours. And equally, a worker doesn't have to accept work when it's offered to them. So it's really popular. NHS bank staff, for example, casual hours workers, students doing work over holidays. The care industry has a lot of 0 hours contracts, delivery driving. The whole gig economy is really based on 0 hours contracts. So lots of use of that in the UK, but people on 0 hours contracts still have rights and can be legally classed as either an employee or a worker, depending on the circumstances. And that has a different, that plays a part as to what rights someone would have. So if someone is a worker, they still have rights to paid holiday and the national minimum wage and things like that, but they don't have rights to unfair dismissal or, redundancy. So it does make a difference what the status of somebody is. And talking about status, I think that's my next point. sorry, did I have the wrong slide up while I was talking about that? I do apologise. So talking about status, we've got new guidance now issued by the government on the 26th of July, because the government was going to legislate to give employers better understanding of employment status issues. But they decided against that and issued this non-statutory guidance instead, making it much clearer, though, what rights are attached to what category of status. There's only 3 status options: genuinely self-employed, employee, and then the one in the middle, which is this worker category. And that's the one that causes most of the issue. And we see lots of case law about, am I an employee? Am I a worker? Am I genuinely self-employed? So if you've got atypical people, I would call them, in your workforce, or your clients do, and you're not sure what their genuine status is, then it's a good idea to look at this guidance, which is really helpful, and check. And also on the gov.uk website, you can go through a series of questions to help you identify what the status would be. Unfortunately, the tax rules are different to employment law rules, not completely different, but different enough for that to be an added complexity and complication. And getting the status wrong could also have IR35 implications too, the whole off-payroll working piece. So worth having a look and making sure, if you've got these atypical people working in an organisation, that we're sure what status they have and therefore what rights they have, because obviously getting it wrong can be rather expensive. Okay, should try and put the right slide up this time. So 2023, just going to recap what happened earlier this year for you. Let's look first at a very important piece of legislation. So this is designed to speed up the process of reforming EU-based legislation. So on the 7th of July this year, 2023, the consultation period for this retained EU employment law bill closed. And what was the big sunset clause, it was known as, which I did speak to you about earlier this year, which would have revoked all EU legislation in one go en masse at the end of 2023, did not make it through the process and has now been scrapped, meaning that there will be no wholesale elimination at the end of the year. And changes will still happen, but they'll be more minor, but could still be consequential differences that could be cemented into employment law going forward. And the UK government has definitely confirmed their intention that any legislation changes will still preserve existing rights, such as maternity leave, annual leave, protection for part-time or fixed-term workers, and so on. So I don't think we're ever going to see a massive change in protection and rights that people have working in the UK. But the legislation gives government ministers new powers to make EU-based laws different, or to repeal them or reform them. And that applies to any EU-based law introduced into the UK by a statutory instrument. For example, the Working Time Regulations of 1998, EU-based legislation. But it obviously won't apply or make any difference to EU-based laws that have been signed into law by our own parliamentary process. For example, we've got the Equality Act of 2010. Well, that's not going to be affected by this. So I don't think there's going to be any dramatic change to existing employment law immediately. There are some reforms already published for consultation. So, for example, when it comes to holiday entitlements under EU legislation, the annual leave is a minimum of 4 weeks under the EU Working Time Directive. And then we have a UK domestic right to additional 1.6 weeks, making what we're familiar with, which is 5.6 weeks of leave. So the consultation proposes that we just merge those two entitlements into one, just so it's far less confusing. So no gains to employment law, but just a simplification. And then there's talk about rolled up holiday pay for irregular hour workers, including workers on 0 hours contracts. So it looks like employers will be permitted to either give an annual leave allowance to those irregular hours workers based on their last year's hours, with holiday pay based, therefore, over the last 52 weeks. Or the second option might be to roll up holiday pay instead of paying holiday. And that would mean those irregular hours workers would receive an additional amount on top of their regular pay to account for a paid holiday entitlement. And employers would add an additional 12.07% to a worker's pay, as that represents the portion that 5.6 weeks is of our statutory annual leave allowance. Obviously, that percentage would need to be higher where people have additional contractual holiday over and above the 5.6 weeks minimum. So that's another consultation that might take place. And I think that would make life a lot simpler for a lot of people managing annual leave for casual workers and irregular hour workers. There's also a change to the maximum working hours record keeping. So while there's no plan to remove the limit on the average working hours, the proposal is to remove the requirement that we maintain records showing the average time of each worker. And the average, unless someone has opted out of the working time regulations, the average is 48 hours per week, calculated over a 17-week reference period. So that part isn't changing, but the requirement to record hours worked might do. And then the last one I've heard about is looking at TUPE, which is, for those of you not familiar, the Transfer of Undertakings Protection of Employment regulations. And the government's consulting on proposals to simplify some requirements about employee representatives for the purpose of TUPE consultation. TUPE is a massively complicated piece of legislation, and the changes proposed are very small. But really, we need to wait and see what happens. But my point here is the sunset clause is gone, so everything won't just disappear and be replaced with something else, but we may see some of these minor changes start to trickle through. I'll, of course, let you know as and when. And then there's this whole cluster of change that's been spoken about for some time, and I've definitely spoken to you about them in the past, and some of them are now going to become law. Numbers 1 to 8 on that list, I'm going to talk about when we look at the future. As for number 9, the Data Protection and Digital Information number 2 bill, the government introduced this bill on the 8th of March this year and withdrew its previous Data Protection and Digital Information bill. And that bill aims to make the EU GDPR legislation that we work to more practicable and less burdensome for businesses in low-risk situations, while still maintaining a good standard of data protection. So this is all about simplification for low-risk businesses. So I won't tell you any more about that at the moment because it's a long way off, but it could be quite welcome. Particularly, it's looking at simplifying the circumstances where data subject access requests can be refused, talking about whether every employer needs to have a data protection officer. So there might be a few things that would help some lower risk businesses in that. And then the other thing there, number 10, the other point is the miscarriage leave bill. And this is a bill aimed to give 3 days of statutory paid leave to employees who have experienced a miscarriage or ectopic pregnancy or similar before 24 weeks of pregnancy. A second reading in the House of Commons is scheduled to take place at the end of November. But so this is a long way off becoming legislation. But however, those 2 things are still in the offing and in the process. So we will obviously let you know what happens with them as time goes on. So now I want to just cover the statutory rates and calculations that we have this year. So very quickly, I think we've got a question now. How many years since the National Minimum Wage Act came into effect? And if you can answer this without Googling it, it would be great. So how many years have we had the National Minimum Wage Act? Have we set a national minimum wage for all employees in the UK? So you've got some options there. I think this might be an easier question. So, another split response, 12% 10 years, 25% 15, 38 20, 13 25, 12% 30. It is 25 years since the legislation came in, so 13% of you were right. It was in 1998 the National Minimum Wage Act became law. I was looking at how old some of our legislation is the other day for, well, it doesn't really matter why, but somebody had asked me about it. And the first discrimination protection legislation we had was actually the Equal Pay Act in 1970, with thanks to the 1968 strike at the Ford factory in Dagenham. So we had equal pay for men and women. The equal pay legislation protected only men and women. And then the next bit of protective legislation was 5 years later with the Sex Discrimination Act. So that's now 48 years old, followed soon by the Race Relations Act in 1976. So all of those things, though, of course, were repealed in 2010 when the Equality Act came in, and I think some sort of 150 plus bits of legislation disappeared and were incorporated into the Equality Act of 2010. So that kind of merged everything and simplified things. But national minimum wage, 25 years old this year. And these are the current rates for you. Underpayment is still a massive problem, sadly. The most significant role in national minimum wage enforcement is played by HMRC, as I expect you to appreciate, and they've got the power to instigate investigations into employers and order them to pay both arrears to the individuals and financial penalties as well. And in the last year, for which we've got figures, there was 16.3 million owed in arrears to more than 120,000 workers, and 696 penalties were issued, totaling 13.2 million in penalties for non-compliant employers. And the HMRC names and shames these employers, and there were more than 200 companies outed by the government this June, actually, for failing to pay the national minimum wage. Often it's a mistake in calculation, it's not intentional, but they also published the excuses people gave or employers gave for flouting the law. And I read through some of them after the announcements back in June. And the first one that stuck out for me was, well, she doesn't deserve the national minimum wage. She only makes the tea and sweeps the floor. Or the employee was not very good, so I didn't think they should be earning as much as the national minimum wage. And it's almost mind-blowing. And then there's the sort of race-related ones. My accountant and I speak a different language. He didn't understand me, and I didn't understand him, and that's why I haven't paid the right money. All very strange. There you go. So, I mean, it's really clear-cut to how that should work. And it was announced, I think, on the 2nd of October that when it's increased next year, the national living wage, which is the 23 plus age range, will be at least £11. So not a dramatic increase, but does make a big difference potentially. But we don't have any of the dates yet. So that's the national minimum wage. Next, we've got the family-friendly statutory payments. So that was the 2nd of April. So this is statutory maternity, adoption, paternity, shared parental bereavement. There's a whole range of those that have the same statutory minimum rate, which is went up from £156.66 to £172.48. And did you know that the amount of statutory maternity pay that an employer must pay is dependent on something called the 8-week reference period. So when someone is going to go on maternity leave, in order to calculate how much maternity pay they should receive, you have to look at what they earned in the 8-week period, which is 8 weeks back from the 15th week before the expected week of confinement. Now that sounds very complicated. So a few key dates. We have something called the expected week of confinement, which is basically the due date. And then we have the qualifying week, which is going back 15 weeks from the due date. And then the 8-week reference period is the 8 weeks before the qualifying week. So whatever a woman earned, if we're looking at maternity pay as an example, in that 8-week reference period is what's averaged to work out maternity pay. So if she received her annual bonus in that 8-week reference period, that's going to shoot up how much maternity pay she would receive. If she had commission payments or overtime payments, that would all increase her maternity pay. So you don't work it out on normal earnings, you work it out on the 8-week reference period. Even if the bonus covers a whole year's worth of work, it doesn't matter, it's the point of payment. So it's quite interesting that it's a little known fact. I'm sure if you work in payroll, you'll be very familiar with that, that it does make a big difference to how much somebody earns. And remember that the first 6 weeks of maternity pay is worked out at 90% of that normal figure. So that's where it makes most of the difference, because after that you go on to the statutory rate, obviously. And also, if a woman is entitled to a pay rise at any point up until the end of her maternity leave, that pay rise must then go back to the calculation of maternity pay, and any increase should be paid to the individual. So even if the increase is not backdated to that reference period, it wouldn't matter. You still, if there's an increase at any point in maternity leave, you still go back and recalculate it. I'm sure you're aware of that. Okay. Oh, sorry, gone too fast too quickly. There's also the SSP increase there. Sorry, that went up to £109.40. And additionally, statutory redundancy pay had a new cap on the calculation of what is a week's pay if you go with statutory figures, and that was £643. So that means the total amount of redundancy pay, the maximum amount anyone could receive, is £19,290. That's if they're in the older age range category and they've got 20 years or more service, because I'm sure you're familiar that it's all about how long you've worked somewhere and how old you are as to how that is calculated. The gov.uk website has a calculator facility if you ever need to use it, where it works it out for you. So yeah, that increased as well on that date. And then going forward to the last change, which is related to employment tribunal compensation. And this is how much somebody might receive if they've been unfairly dismissed. That increased too, and it went up from, I can't remember what it was before actually. It normally goes up by 5 or 10%. So I think this time it's 105,707 or 52 weeks gross pay, whichever of the two is the lower. So that's the ceiling, that's the very most somebody can win. And compensation is calculated in two parts. First of all, people get a basic award, which is the same as the statutory redundancy pay calculation we've just been talking about. And then they get a compensatory award, which is loss of earnings essentially or primarily. And that's this figure. Okay, when it comes to discrimination, and we're going to talk a bit more about that, because that's one of the topics for today, the ceiling disappears. There's no maximum compensation if someone's successful in a discrimination claim, and they also are eligible for an injury to feelings payment. And on the 6th of April 2023, we had the new Vento bans. It's called Vento because this was a case many years ago that introduced this band feature to Injury to Feelings Awards. And each year the 3 categories are increased slightly. So this applies to discrimination claims presented on or after the 6th of April. And people are awarded an injury to feelings payments according to how hurt and humiliated and upset and affected they've been by the discrimination that they suffered. So, you know, there was, if it's a low level one-off type issue, I remember a case called Rawnsley and Queenieburgh, and this was where it was an age discrimination case, and there were demeaning comments said to a young employee by their manager, referring to them to things like a spoilt child and any child could do better than you, things like that. And even though the manager promptly apologised after he found out that he had upset this person, and they were awarded £1,000 as injury to feelings. Now, the bands were lower when that case was heard, but that kind of gives you an idea for the bottom end, maybe would be right at that lower end of the first bento band. But obviously, the more serious cases, the higher the compensation. Good. So as to what it will be next year, we just don't know. The only indicator we've had so far, and I did check a day or two ago, was that the national living wage, the top one, would be at least £11. So that's all the information we've got so far. Okay, so we're going to move on to now thinking about our first main section. So we've got 4 key sections to look at. The first one to explore is the recruitment contracts and interviewing. And there's a few things we need to think about at the hiring stage of an employee's life cycle. And I've put them up on the slide there. So we need to avoid discrimination. We need to think about health questions and health questionnaires. There's data protection implications right from this point onwards. The right to work and immigration status, the contract that we're going to use, the contractual status of the individual. I've mentioned that to you already, so we won't recover that. And then we need to just quickly think about references. ACAS have great resource on there, as does the gov.uk website. So if you ever want to look at something in a bit more detail, like how do I do a right to work check, it's really detailed, really straightforward and set out on both of those sites. And we don't have enough time to go into too much detail today. So avoiding discrimination is a really important issue when it comes to recruitment and selection and interviewing. And it is a section in itself a little bit later on, but I just wanted to remind everyone that this obligation not to discriminate applies before you've actually employed somebody, because the Equality Act relates to how you select and treat candidates that apply for a job with you. So discrimination is very simply the unfair and unequal treatment of an individual by reason of a protected characteristic. And I've got age as the protected characteristic in this picture, but obviously there's many others. There's 9 in total that we'll look at a little bit later. And recruitment discrimination may occur if an employer selects a candidate for a legally unfair reason. So we need to focus on qualifications, knowledge, experience, and their behaviours, their ability to do the job in the way that you want it done. And this can be an issue from shortlisting through to interviewing, through to who gets selected, through to how much you're going to pay somebody. And the Equality Act actually states that we mustn't discriminate, 1, in the arrangements you make for deciding who to give the job to, 2, the terms that you're going to give that person, and 3, you must ensure that you don't harass a person who's applied for a job with you. And it always surprises me that that's specifically picked out, number 3. You shouldn't harass a person who's applied for a job with you. And then I came across a case recently where someone was harassed when they applied for a job, and it was a firm of solicitors called AA Solicitors. And this person went for their interview, and the line manager that they would have interviewed them and clearly took a shine to this paralegal. I haven't got time to tell you the whole story, but was very inappropriate, and ended up actually asking them if they would marry him. at the interview, and that's got to be pretty unusual. He talked about having to work late, and maybe I'll get a bed installed so people can have a nap at work, and it might be just you and I late in the office, and all those kind of things. So very strange, awful interview for this person. She was offered the job, and amazingly, she took the job, but decided to have a fictitious boyfriend ready to talk about, in the hope that that would eliminate this problem when she started. Unfortunately, it didn't. And instead of being still very amorous, I think might be a good word to use, it turned quite nasty. And in the end, she was dismissed. She didn't work there for very long. So she brought a sex discrimination claim for sexual harassment. And I don't think you'll be surprised to hear that she won. And she won £20,000. 14,000 of that was her injury to feelings payment, because she got another job very quickly, so little loss of earnings. Actually, the person in question appealed this decision. It was brought against the employer and the employee personally, and at the Employment Appeal Tribunal, the judge said, there's no appeal here. She deserves every single penny of that £20,000, which again, I'm not surprised to have heard. So we shouldn't discriminate when people come for interviews and in any of the selection stages of recruitment. And if you have standard questions that are work related, you're not going to go wrong. And if you keep a good record of an interview, you're going to have evidence as to why you picked one candidate over another. So just some basic good recruitment process will eliminate these kind of issues. On health questions and questionnaires, Section 60 of our Equality Act says that we should not be asking potential recruits questions about their health before a job offer is made to them. There's some limited exceptions, which I'll mention, but it basically means that employers need to be really careful about the questions they ask people during recruitment in order to avoid disability discrimination, because that's where the health questions could lead to discrimination by reason of disability. And also, employers shouldn't send any sort of general medical questionnaires until after the job offer is made too. Now, the exceptions are in particular two clear ones. The first one is if there is some aspect of health that's intrinsic to the job, then it's appropriate to ask. So if someone is going to carry heavy weights on a building site at height, then it might be appropriate to ask if they have any health conditions that could be affected by that work, or that the employer should know about that relates to that work. So that's intrinsic to the job. If someone is, in a sedentary role, working in an office, there's far fewer chance of anything being intrinsic to the job. The other exception is where you make health inquiries to find out if you need to make any reasonable adjustments to any part of the recruitment or assessment process. So it's very common and completely appropriate when you invite someone to participate in a recruitment process, that you set out what the process broadly is, and ask whether they have any health issues or disability that might affect their participation in that process and might need some reasonable adjustments. So you would ask those questions ahead of time. And there's been quite a few cases recently, which if we do a case law update, I'll go through with you, that are about neurodiversity and the impact that has on people, both in the recruitment process as well as employees. So as I said, when you think about how to do a recruitment process, bear in mind these kind of points. When you think about your interview questions, make them work related, focus on the essential and desirable criteria in your job descriptions, have standard questions that you ask all your candidates and assess those ones. You can, of course, ask specific questions of a particular candidate. On reading your CV, I see there's a gap, in employment. Could you tell me what happened during that gap? Or I see you moved from this job to that job, which is quite a curious change. Can you tell me why you did that? No, that's fine. But you can't really score those questions. You can only score the standard questions that are role specific rather than candidate specific. And also, when you ask questions, make sure that they're not leading. I've sit in on lots of interviews, and I'm amazed at how often I hear leading questions asked. You know, I was with one not so long ago where the question was, it's really important that you work well in a team. Can you tell me about whether you're a team player? Like, of course, the person's going to say, oh, yes, I'm brilliant in teams. You know, and then I saw the person interviewing give that a big fat tick, like, brilliant, they're a great team player. You know, I think we've got to be far more intelligent about how we ask those questions. Episodic or behavioural based interviewing is by far the better option. You know, can you tell me about a time when you worked within a team and you just get someone talking? And then you might ask the question, well, you know, did that team ever have conflict or difficulty? Get them talking. So you don't ask the question at the beginning, you ask the question at the end. So once someone is firmly rooted and thinking about, yes, I remember that particular team. Oh, yes, there was some conflict, you know, and then you say, so what happened? You know, tell me a bit about it. And you ask your questions in that way. And what that does is make a person speak from their experience rather than what they think you might want to hear. So they respond with how they did behave rather than how they think you might want them to say they behaved. Anyway, we're not doing an interviewing session today, but there's lots of ways to make interviews really effective. And also, if you want to put someone at ease, which we should do, I think, to get the most out of somebody, I would never start an interview with tell me about yourself, because people often reflect that to mean you want to know about them personally. I would start an interview with tell me a bit about your current role. It's really easy. Everyone can talk about that, and gives you a way to kind of relax the candidate. Anyway, you know, avoid questions that are personal. We don't need to know how many children someone's got or who they live with or any of those things. You know, keep them work focused is probably the easiest thing to do. I want to touch on data protection, but kind of super quickly, because this is something that applies throughout employment. But when you start to collect data from recruitment onwards, that person is able to raise a data subject access request and receive a copy of that. So interview notes, you know, if they're stored in a recruitment portal or on an employee file or on a recruitment file, remember these might have to be disclosed. So think carefully about what you write down and what you retain and how you retain it. I also want to just mention on terms and conditions, documentation is essential, as you'll all appreciate. All employees and workers are entitled to something called a Statement of Employment Particulars. This is Section 1 of the Employment Rights Act of 1996. And that document should set out their terms and conditions. This can be a standalone document. Sometimes you see it, all the information needed going into an offer letter, or people incorporate the requirement into a contract of employment. Again, you can find out everything that should be in there if you go on the gov.uk website and look up the terms and conditions, essential documentation. But that should be provided on or before the start date for whenever someone's going to join that employer. And there's a whole list of things that you should cover. Obviously the basic, who the employer is, how much you're going to earn, what your hours of work are, but there's a lot more that should be incorporated. But of course, most employers would wrap that up into an extended document called a contract of employment. And on the contract, by way of a kind of gentle reminder, please remember that an employment contract is formed when an offer is made and accepted. So if you verbally make a job offer and someone verbally accepts, that's the contract formed. So job offers should be conditional upon signed contracts and satisfactory pre-employment referencing and vetting. So let's make them conditional until the point the contracts are signed and you do then whatever reference checking or other pre-employment checking that you want to do. That way you can withdraw from that process without any notice being payable to somebody, because if you have a contract and then you change your mind, you then have to pay notice. And contracts are made up of express terms, So they're the ones that have been agreed either orally or in writing. They're made up from implied terms. They're the kind of custom and practice, things that are too obvious to need recording. There are statutory terms. You don't need to set out how much maternity pay is if you pay statutory maternity pay, because the law does that. And then there are incorporated terms. And this is where the contract references other documents. It might talk about our staff handbook. Its reference to that document incorporates it into the contractual mix. So we need to be clear whether, policies are contractual or not, or intended to be contractual or not. And so lots to think about with contracts. And then the last point to raise on this is the atypical workers. Remember, people have rights, whether they're fixed term, part-time. It's all about no less favourable treatment. And also we need to get that status issue right. So, a part-time worker should not be excluded from benefits or from any particular benefits. Obviously, if you give a company car, it's really difficult to give 50% of a car. So this is where car allowances make sense, which I'm hoping is pretty obvious. And if you use agency workers, they have rights. There's lots of legislation to protect agency workers as well. For example, they have the right to equal treatment with the permanent employees if they're in a 12-week placement or above. So lots to think about if you use agency workers as well. Okay, let's just cover the reference point before we have our first break. So question for you, myth or fact? You cannot give a bad reference. Is that true or false? Myth or fact? I'll just give you a second to pick. Can you give a bad reference? It is a myth. Very good. You're right. 68% of you are right. So an employer is permitted to provide what might read as an unfavourable reference. You can't give a discriminatory reference. That's something entirely different. But it might be unfavourable if the employer believes that the provided information is true and accurate and non-misleading, and there are reasonable grounds for making that determination. So, of course, if a worker receives a bad reference which they believe is unfair, then they can bring a claim against their employer for damages, providing that they can prove that the reference was inaccurate or misleading. And they might also want to claim if they've suffered a loss because of the reference, and the most common loss is having another job withdrawn. And there's an equal duty of care here when you write a reference. You have to think about the person you write about as well as the employer you send that reference to. So, for example, if you had someone in your accounts function who stole money from you, and after investigation that was proven and they were dismissed, or maybe even they resigned before they were dismissed, and a reference request comes in from a new employer, it would be quite appropriate to mention what had happened whilst they were employed with you, as long as it's factually correct and accurate. And in fact, if you don't mention it and that person goes on to steal from the next employer, they might come back to you on a negligent misstatement claim if you haven't said what probably would have been the most important thing to have said. So my advice when it comes to referencing is probably have a policy. If you've got an HR person or someone suitable, have that same person complete all the references so you know it's going to be appropriately done. Think about verbal references as well, because all the same rules apply. There's slightly different rules if you're in a regulated industry like financial services, for example. You can be really brief. The tombstone style is very popular. Name, date of joining, date of leaving, job title, but bear in mind what I've said about serious issues. And just be careful about, what you say. You don't want to be, misleading or inaccurate. Good. Okay, it's a good time for a break now. So we're going to take 10 minutes, let you have a chance to stretch your legs and have a quick comfort break. So we'll be back at 15:15. Thank you very much, and I will see you shortly. Okay, everybody. Hopefully you've had a chance to have a quick break and stretch your legs. I've just decided to have a quick look at the questions, and there was a question about 0-hour employees, are they entitled to statutory benefits, i.e. SSP and SMP? Well, this is dependent on whether the 0 hours person is either classified as a worker or as a employee. And obviously that's where you have to go back to that status determination. So for example, with maternity, workers on a 0 hours worker is not entitled to be paid for time off for antenatal meetings, for example, but a 0 hours employee would be. And when it comes to maternity leave, a 0 hours employee is entitled to maternity leave. A 0 hours worker is not. When it comes to maternity pay, then both employees and workers on 0 hours contracts may be eligible if you pay them through PAYE and deduct tax and national insurance, as long as they qualify. So it's super complicated and entirely status dependent. So once you've got the status worked out, you'll then be able to determine what rights they have, statutory and contractual. So hopefully that's helpful or helpful-ish. Okay, moving on then to our second key area during employment that I've been asked to cover today, and that includes bullying, discrimination and harassment. And this is a big and complex area, as I'm sure you would expect. So for more information, it will again be a light touch, but for more information, look at the Equality and Human Rights website, look at the gov.uk, look at ACAS. You know, those are good places to find great information. And as I said before, the Equality Act is the key bit of legislation here. And as I mentioned earlier, the Act prohibits discrimination against people who possess one or more of the protected limited of the protected characteristics, and that prohibits harassment, victimization, direct discrimination, indirect discrimination, and so on. So there's lots of types of discrimination, and there's 9 protected characteristics, which we'll look at a second. It's worth pointing out, again, I might have mentioned earlier, that claims of discrimination can be brought against both the employer and the individual who undertook the act of discrimination. So it's an area of potential personal liability, just like it is for health and safety, for example. But for an employer to escape liability, they have to show that they have taken all reasonable steps to eliminate discrimination from their workplace. So they've got to have great policies that are up to date, that are well known by everybody, that are regularly refreshed. They've got to do great training. I do EDI training, equality, diversity and inclusion training for some clients every year. They refresh it every year without fail. You've got to make sure that when there is an issue, you jump on it instantly, you treat it really seriously, you take appropriate action. You know, if an employer can tick all those boxes, they may be able to say, I have taken all reasonable steps, so why should I be liable for what this rogue employee is doing to other people in our workplace? So often when you read about cases, it will say the case was brought against, you know, British Gas PLC and Joe Bloggs. And if someone brings and succeeds with a claim at the Employment Tribunal, they're entitled to compensation, which we've discussed earlier. So let's look at the protected characteristics, or remind ourselves of these. If I could have done this as a poll, I would have done, but I couldn't figure out how to do it. So these are the 9. We've got sex discrimination, pregnancy and maternity, race, colour, nationality, ethnic and national origin, gender reassignment, marriage and civil partnership, sexual orientation, religion or belief, age, and disability. So I think some of these are pretty straightforward. So the sex discrimination part references male and female. Pregnancy and maternity, I think that's pretty straightforward what that means. Race covers, skin color, nationality, ethnicity, as well as nationality and national origin. Gender reassignment is a broad category because it doesn't mean that people only have protection if they are in the process of or have changed from one gender to another. It's much broader than that. Somebody need not have any surgery or even go and visit a doctor or a specialist to be protected under the gender reassignment category. They could choose to live as their preferred gender without ever changing a thing about themselves. And also this is an area that also covers non-binary discrimination or gender neutral, because gender is a spectrum. And there was a case a couple of years ago, Rose Taylor and Jaguar Land Rover, where the judge ruled that gender was a spectrum and this part of our Equality Act should protect people within that from less favourable treatment. So that's a broad category. Marriage and civil partnership is pretty straightforward. You're only protected if you are married or in a civil partnership from less favourable treatment. So you're not protected if you're not married or not in a civil partnership. But to be quite honest, there's very few cases. This was part of the Sex Discrimination Act in 1975, because prior to that date, a lot of employers had a policy when women got married that they were automatically dismissed. And in fact, my mum knew somebody who got married. They decorated her desk, they did a collection, they bought her a lovely gift, and the post office sacked her. And I remember saying to my mum, that's absolutely awful. They must have been devastated. And she said, no, she was super happy. She got married and she got to leave her job. But of course, things have changed a lot from the 1950s and 60s to today. So that's marriage and civil partnership. Sexual orientation is gay, lesbian, bisexual and heterosexual protection. So those are the four sexual orientations. Religion and belief is another broad category. So the religion part is fairly easy to understand, but the belief doesn't have to be a religious belief. It has to be a philosophical belief. And there's lots of guidelines on what might constitute a philosophical belief and what might not. And there's lots of case law about what is and what isn't. For example, there's recently been an ethical vegan case where it was found protection should be afforded to an individual. And then literally in the last few months, there's been a second ethical vegan case where it was found protection shouldn't be given. And the only difference between the two was in the latter case, this was a veterinary nurse. She participated in trespass and theft by breaking in and removing animals from certain organisations. And the judgment said, we can't endorse a belief that incorporates breaking other legislation. So it's a very tricky area, religion and belief. Age, a bit more straightforward. Age protects people in any age from being less favourably treated. It's not just about older age discrimination. Well, before I leave belief, I should mention I had a case recently which was about football supporters. So if anyone's wondering, being an avid football supporter is not a belief. And also being a Jedi Knight is not a belief. So we've had a whole spectrum. That was age. And then disability is the last one. That's a pretty broad category as well, because disability under the Equality Act does not have a list of conditions that would afford someone protection and a list of conditions that wouldn't. There is a definition of what constitutes a disability under the legislation, and it's very broad. It says a disability is where there's a physical or mental impairment that's substantial and that someone has had or currently has, and it's long-term and it has that substantial effect on their day-to-day activities. So all sorts of things where someone might never term themselves as having a disability would be protected. For example, you know, someone with very severe migraines or long-term back pain, as well as what you would probably more likely associate with the word disability, you know, wheelchair users, someone with a sight impairment. So again, it's a lot of it is about the effect of health issues on individuals. So that's very briefly an introduction to the 9 protected characteristics. I just want to touch on the different types of discrimination that we need to avoid. So we've got direct discrimination, where a person treats another less favourably on the grounds of one of those 9 protected characteristics, and that treatment is different than they would treat someone else. So a few key things: it's less favourable treatment, it's because of a protected characteristic, and it's different to how someone else might be treated. So if we take a really simple example, I'm not going to recruit that person, they're a wheelchair user. That's direct disability discrimination. The less favourable treatment is not recruiting. The difference is by reason of their disability, and somebody else who doesn't have that disability would have got the job. Okay, so I think that was straightforward. Indirect discrimination occurs when a company applies a provision, criteria, practice, or policy that has the effect of disadvantaging members of one of those 9 protected characteristics, and that is unlawful unless it can be objectively justified. So it doesn't look like discrimination necessarily, because we apply that criterion or policy to everybody, but in reality, some people, because of their protected characteristic, are disadvantaged and therefore indirectly discriminated against. And a really simple example for this is many years ago, the police force had a minimum height requirement to join the police. And that was the same for men and women. And that was claimed to be indirectly discriminatory against women. And therefore it was removed because they were unable to say that there was sufficient objective justification for that height requirement. You might have a workplace that allows people to take an hour for lunch between, 1 and 2. And somebody may say, well, I would like to split my hour into 3 different breaks because I'd like to pray during the day. And if an employer said, well, I'm really sorry, we just want the 1 break, we're treating everybody the same way. So we're displaying equality. So we're going to have to say no. That would still be indirect, in this case, religion-based discrimination, unless they've got some very good reason for not being able to allow somebody to split their break. Okay. And also part of direct discrimination is something called discrimination by association and discrimination by perception. And by association is where somebody says, I feel less favourably treated by my association with my children who have a disability, and therefore I have a claim of direct associative disability discrimination. So let's say, somebody asked for flexible working because of the disabilities that their children have, and their employer unfairly denied them that flexibility. Then that would be their complaint. If their employer had very good reasons for not allowing the flexible working, then we know that the flexible working legislation accounts for that. Direct discrimination by reason of perception is the last example. And this is where someone feels less favourably treated than another, but they don't have the protected characteristic. However, they are perceived to have it, and that's why they have that less favourable treatment. So the example actually in the guidelines to the legislation talk about someone at work who looks very young, but isn't very young. However, their employer decides because of how they look that they don't want them to represent the company with a particular client. So the less favourable treatment because they think they look young. Nice problem to have, but the discriminatory effect is the same. Okay, and then the final two definitions are harassment and victimisation. I do like my kissing couple, whether it's harassment or not, I don't know, but it looks like an age-friendly workplace, and he definitely has too many fingers and she has too few. But anyway, so harassment is unwanted conduct related to a protected characteristic that violates a person's dignity or creates an intimidating, hostile, degrading, humiliating, or offensive environment. And I think people are more familiar with harassment than perhaps some of the other categories, you know, whether that's spoken or written, you know, abuse, offensive emails, offensive jokes, you know, tweets, comments on social media. It could also be physical. I mean, I'm amazed that this still happens, but there was a case reported in the last couple of months where a woman was smacked with a ruler on the backside at work amongst some other sexual harassment, and brought a claim and won £90,000. But, you know, I'm amazed that we would still have to say to people, just in case you wonder, please don't hit other people on the backside with a ruler, because that's deemed to be harassment. But there you go. So harassment can be physical, but it has to be unwanted, and unwanted is the same as uninvited and unwelcome. Victimisation is less favourable treatment because someone has brought or is bringing a claim of discrimination, or they're giving evidence on someone else's behalf, or they've alleged or made a complaint about a discriminatory issue. So maybe someone's raised a grievance at work, and their employer, instead of hearing that grievance and dealing with it appropriately, just says, do you know what, I'm just going to move you to a different job, in a different team, in a different building, and that'll solve the problem. So that person would then have whatever their original grievance was about. And then the victimisation is in two parts. One, you didn't follow the internal complaint process and allow my grievance to be dealt with appropriately. And two, you've taken me out of my job and put me into a job I don't want. So original discrimination issue, two types of victimisation, failure to follow an appropriate process, removal from the job. If, of course, the employer said, would you like to just, you know, move to a different job, would that solve this issue for you? And the person says, yes, please, that would be great. They're not going to complain of victimisation, but you'd want all that agreed, file notes of conversations, followed up with letters and so on. And also victimisation applies to people who come out in support of others. Lots of companies are introducing something that's called an upstander model, or an active bystander, which is all about encouraging colleagues to look out for each other and call out inappropriate behaviour when they see it. And part of the reason for that is that we often don't see where we go wrong, but other people can see it. And so, you know, helping by sharing where someone goes wrong is a valuable thing to do. But nobody should be retaliated if they do that, if they come out in support of someone else in relation to a discrimination issue. Okay, good. Oh, that's the ruler case. That was to remind me to tell you about it. We don't need to dwell on it any longer, but there was also another case in the last few weeks reported, which was where a female executive was bombarded with peach emojis by her boss, amongst a whole range of other sex discrimination matters. And she has just been awarded £420,000, which included a £30,000 injury to feelings payment for the sex-based harassment and victimisation that she experienced. And this was a company called Voca Rail. And obviously this person had taken a liking to this individual, and it's widely known that the peach emoji refers to someone's bottom. Despite her rejecting his advances, he continued, lots of suggestions. He even suggested that they might want to move abroad and live together and start a business together. He rang her when he was drunk. He sent her endless suggestive messages. He basically behaved a bit like a stalker. On one of the messages, he said, "I hope it's now obvious that I really do like you. I'm just not good at saying so." Well, you know, you'd wonder what else he would need to do. If you don't feel the same way, that's cool. Let me know. But if you do, that would be great, or words to that effect. And then he must have thought a bit better of it the next day and said, or we could just forget I sent that text. However, she eventually resigned and brought a claim. And she also complained that her company had not dealt with her complaints appropriately. She felt that her salary had been affected by her refusing her manager's advances. You know, there was a lot more to this case, but I hope it goes to show how very expensive it can be, you know, when issues like that happen and when they're not dealt with appropriately in workplaces. Okay, good. I just want to go back to that definition of disability very quickly. As I said, there's, you know, it's not clear what conditions are and are not captured by this definition. And that's why medical advice, engaging with the individual concerned, thinking about reasonable adjustments, which we'll come on to in a second, to support somebody if there is an impact that affects either them coming to work or when they are at work. These are all things that we can do to be positive and inclusive for people with disabilities. There's also been a very interesting case recently where baldness was found to be harassment. It was brought as a claim of disability discrimination, but it was found to be age-related discrimination. So curious. However, let's look at the reasonable adjustments that we're obliged to consider. Under the Equality Act, we have to make sure that everybody has access to has the same opportunity for access to jobs, as well as education and services. It's not just about jobs as non-disabled people. And therefore, this sometimes triggers this duty to make reasonable adjustments. It's a real pillar of the protection in the Equality Act. And this could be anything from, you know, adaptations in the workplace, you know, an assisted keyboard, to enabling someone to have a parking space near the entrance of a building. I mean, I've listed on the slide all the different things that you might be expected to look at, but it is reasonable adjustments. So there is that caveat that it should be reasonable. However, even small employers have got access to, you know, free resource. If you employed someone on the autistic spectrum, then there's plenty of advice from the Autistic Society as to what you might be able to do to support someone. There's lots of free resource and support from the government to either enable people with disabilities to get jobs or to remain in employment when the impact of that disability is affecting them. So, you know, look out for that. There's lots available for people to assist them. Excuse me. I wanted to mention this case because I think it's quite an interesting one. It's about reasonable adjustments in recruitment, and I did touch on it a bit earlier. This is Rackham and the Judicial Appointments Commission, and it, for me, really demonstrates the fact-specific nature of disability cases. And there's a well-known saying that in relation to autism that says, when you've met one person with autism, remember you've only met one person with autism. Just because it is a wide spectrum, and the way people are affected can be very different, and the implications of that can be very different. And in this case, Rackham had autism spectrum disorder and Asperger's syndrome, that caused him difficulty with one-to-one communications. And he asked, as part of this recruitment process, for a reasonable adjustment. So he asked for them to simplify the written questions in a skills test, or to allow him to complete a practical task instead. And given that the questions were designed to replicate the requirements of the job, They argued that it would be too difficult to do that, to turn something into a mock scenario. So instead, they made the following reasonable adjustments. They said they would give extra time for the completion of the test. They would give the assistance of someone that he knew to help, and they allowed him to submit his answers offline by email. And they said it wasn't reasonable to provide a trained autism facilitator, which he had asked for, as instead they had been in touch with the National Autistic Society, who had advised that it would be far better for someone he knew to assist rather than someone he didn't. So they had sought advice from this very relevant charity and made some other changes. However, he brought a claim against them, but he was unsuccessful. And the tribunal noted that they'd made a lot of adjustments, as much as they could, but because the recruitment process was entirely relevant to the ability to do the job, it was not appropriate to make any further changes. So every case turns on its facts, but this is a case where the company had given, very careful consideration to reasonable adjustments, had taken lots of very good advice, thought very carefully about it, made some adjustments or suggested some adjustments as well. And those are the kind of things that you would need to do to show that support. Okay. The third of the 4 key areas that we're going to look at is grievance and other complaints like whistleblowing. So that's the next one I've been asked just to touch on today. And every employer needs to have clear policies, not just in these areas, but in all areas. But obviously grievances and whistleblowing is very important. The reason I think policies are so important is because when you have an issue, you don't want, on top of everything else, to be trying to think, how should I be dealing with this? So some good standard policies that steer people process-wise are just really valuable. And it's also a legal requirement when it comes to grievance and disciplinary issues that you have a policy. So it is a requirement. For something to be a grievance, the word grievance doesn't need to appear anywhere. And that's an important point. So if people raise complaints and concerns, they don't have to say, this is a grievance, or I would like you to refer me to the grievance policy. It's for the employer to make an appropriate decision. And grievance policies allow for informal management as well as formal management. And I wish people would use mediation more with grievances. I mean, I say that as a mediator, but it's such a quick way to deal with issues. It enables people to speak to each other, which they never do in a grievance process. There's so many benefits, I think, to attempting to mediate an issue. They're not all relevant for mediation, of course. It does depend on the issue. But there's lots of case law. ACAS have a great code of practice for how to deal with a grievance, what a fair process looks like. Typically, a grievance procedure will have 3 stages. Firstly, the employee sets out their grievance in writing, think informal management and mediation as well. Secondly, the employer will investigate and invite that person to a grievance meeting, and they have the right to be accompanied by a colleague or a trade union official. And then a decision is reached and it's given in writing. The whole point of a grievance is to find a mutually acceptable remedy, if at all possible. So when people raise concerns, ask early on, what would put this right for you? What would you expect as an outcome to your grievance? So let's get that known as soon as possible. And then if once they have their written outcome, they're still not happy, then the 3rd key stage is the right to appeal. Again, invite to an appeal meeting, right to be accompanied, and eventually a written outcome. And people have the right, as I said, to be accompanied to both of those, the grievance meeting and the appeal meeting. And anyone that accompanies someone has the right to be paid for the time off, should not suffer a detriment because they've chosen to do that. Should be treated no less favourably as a result of that. Whistleblowing is obviously different to a standard grievance. A grievance is about your personal circumstances whereas whistleblowing comes from legislation called the Public Interest Disclosure Act, the PIDA Act of 1998. And this type of grievance is where an employee is raising concerns about wrongdoing or malpractice in the workplace that's supposed to have more of a public interest aspect to it. And that's why it's got its own legislation. And a whistleblower is protected by law from unfavourable treatment, or if they are dismissed, i.e. they lose their job because they, blew the whistle. And it covers things like raising issues about criminal offences or fraud, for example. Someone's health and safety is in danger, so dangerous practices. There's risk of damage to the environment, for example. There's the company is breaking some legislation or another, or if you believe someone is covering up wrongdoing. So there's lots of different types of whistleblowing issue that should be incorporated into that policy. Now, sometimes the public interest can just be other employees. So there was a case called Chesterton Global Limited versus Numero Mahid, and this was where an employee brought a claim that the employer was not fairly representing a particular aspect of their accounts, and they were doing that to lower the bonuses of 100 different employees. And that was found to be correctly managed under the whistleblowing legislation. And the public interest issue there was there were 100 people affected. So don't just think, oh, it's only employees involved here. That probably won't be whistleblowing. It's a complex area. So again, sometimes good to seek advice if you need to. Good. This is an interesting case. It relates to a dismissal case relating to grievances. And I've certainly had a number of clients in the past stuck with what I would call a serial complainer. But the question is, at what stage, if at all, can an employer safely decide that now enough is enough, where there is a long-term line of unsuccessful grievances? So can an employer dismiss an employee in those circumstances? And dealing with an employee who repeatedly raises grievances must be up there as one of the most frustrating jobs the line manager or an HR advisor might have to deal with, because resolving grievances is time consuming. And when you add in the emotional intensity that often accompanies complaints, you can see why energy levels get depleted of people having to deal with them. And I'm often asked, is there a point where you say, the end of our tether has been reached? And in this case, Hope and British Medical Association, we've got a little bit of guidance on that. Now, the facts of this case are that Mr. Hope was a senior policy advisor and had particular responsibility for professional regulation. And his work performance was deemed to be really good, and he got on well with other people. That is until a dispute arose about a report he had written, which had to be signed off by a more senior manager and included some comments which that manager considered to be unprofessional and dismissive of the views of a colleague. So it starts with this dispute about this report. And Mr. Hope took umbrage about that, and he said he wanted to raise a concern. Before that was resolved, however, he raised a second issue, and this time it was about his line manager, who he said was now excluding him from regular catch-ups on a particular matter he was assisting with. So the first grievance was heard and the employer rejected it. His appeal was only partially upheld on one point, and there were some suggestions made about improving Mr. Hope's relationship with his managers. However, over the next few months, Mr. Hope raised numerous other concerns, mostly about being excluded from particular meetings he thought he should be attending. He didn't accept that it was up to his managers to decide who should go to these meetings. And when informal discussions were had and stalled, he was then invited to escalate his complaints via the formal process so they could be determined. However, he refused, and he made it clear that he didn't want his complaints to be heard as formal grievances. but he did want to be able to refer to them again in the future should he need to, which puts an employer in a really difficult position because they're unable to deal with a matter and it just sits, waiting. So it didn't go down well. And they did a very sensible thing. They gave him a timeline and a deadline to decide whether or not to invoke the formal grievance procedure about any of those outstanding matters. So he was given a cut-off point, either raise them or we put them to bed. And in response, guess what he did? He raised a grievance about that decision. And while this was ongoing, he actually raised another grievance about another meeting he thought he should have been attending. And in the end, I think he had 7 grievances, at least 6 of which were outstanding. And this was over a short period of time. And only one of those had ever been formally resolved. So what they did next was they invited him to a formal grievance meeting in order to hear. They collected all those outstanding issues and they invited him to a formal grievance meeting to deal with all of those things. By this stage, the relationship was very, very broken. I think it would be a good thing to say. However, he refused to attend that grievance meeting. So what they decided to do was hear the grievance process in his absence and reach a determination and make an outcome. And they decided that Mr. Hope's behaviour was considered to be frivolous and vexatious. And because of the manner in which he approached his grievances and his failure to turn up at the meetings and so on, they decided that this was a disciplinary matter. So he was then referred for disciplinary action following the outcome of that grievance. And to cut a long story short, he was eventually dismissed for gross misconduct on the basis that his actions had fundamentally damaged the relationship he had with his employer. And gross misconduct is where you're dismissed unilaterally without any notice or pay in lieu of notice. He appealed internally against that decision, but that appeal failed. So he argued he'd been unfairly dismissed. He has a tribunal hearing, and the tribunal said that the dismissal was fair. He appealed that to the Employment Appeal Tribunal, his principal argument being that what he had done had not amounted to gross misconduct, but the EAT rejected his appeal too and upheld that it was a fair dismissal. And they said for there to be a fair dismissal, there must be a genuine belief in misconduct. You must have reached your belief on reasonable grounds. There must have been a full and thorough investigation, and the dismissal must fall within a band of reasonable responses open to an employer. And it's that last one that catches lots of people, because a band of reasonable responses might mean one employer would give a final written warning for that, but another employer would say, we've had, X number of months of ongoing difficulty, the relationship is now broken, it's gross misconduct. So there we go. It was, in all the circumstances, they treated his behaviour as such that it resulted in gross misconduct. So lots of implications for employers. I mean, this decision doesn't necessarily give the green light to discipline or dismiss serial complainers without giving it much thought. You can't reject future grievances simply because the last 5 have had no foundation, because that's not appropriate. The legislation says you're entitled to raise a grievance. So you're really only left with these kind of actions as if you've got serial complainers. You've got to put the same amount of effort into investigating grievance 5 as you did into grievance 1. But that's not to say you have to ignore previous grievances altogether. If employees raise similar sorts of issues in the past and you've made changes or determinations on them, then, that grievance process is going to be pretty swift. So, you have to think about what's the right way to deal with it. this case is going to appeal. So he's appealed again, and the Court of Appeal will hear it at some point this year. So it will be interesting to see whether the situation changes at all. But that's what we've got at the moment, that if you follow appropriate due process, then at the moment it looks like there is a route through for dismissing someone. Okay, it's just a few minutes too. So before I start the next section, which is the last section, it seems like a good idea to bring our break slightly forward. So if we take another 10 minutes, that would be great. So come back at 11:05. I'll just mute my camera and microphone, and we'll do the last part and then what we're expecting in the future at 11:05. So thank you very much. Welcome back, everybody. So I just scrolled back through the questions, and there was one that's really interesting, which was, I'm curious, many of the examples are females as the victim. Presumably there are also cases where males are the victim, or do we see a reluctance in male colleagues raising harassment and or discrimination of any kind as an issue? So just answer the first bit of that question first. Presumably there are also cases where men bring claims. Yes, there are. I have to say there are far fewer in number. I have personally only sat on one sex discrimination case that was brought by a man. I mean, I'm not setting myself out as representative, but I know the statistics are that by far most of the claims are brought by women, not by men. And then the second part of the question is there a reluctance for men to raise issues? Maybe that does play a part. I can see why that would. Or maybe men feel more comfortable to raise the issue and have it dealt with appropriately internally, within an organisation, rather than take it to a tribunal. We also have to remember the #MeToo movement made a big difference to people feeling confident to raise complaint. So I think there's been lots of factors in there. The bald age discrimination claim was one that I mentioned to you, was obviously a man. But yeah, I think, statistically far more women than men do bring sex discrimination claims. But thank you for that question. Right, back to where we were. So we were just about to start on the fourth section. Let me just get my slide up. Right, so we're in the "you're fired" section now. So it's our final section, when employment ends. And there's options here. We've got by mutual agreement. We've got genuine resignation. Of course, there are resignations that are forced, and they're called constructive dismissal. But if it's a genuine resignation, then that's how employment can end. There's where the employer ends the employment, and that can be either through any of those 5 potentially fair reasons that are applicable in the Employment Rights Act. So whether we dismiss by reason of conduct, by poor performance, for sickness absence, for redundancy, for a statutory ban. So under some other legislation, we can't employ that person any longer. Imagine the lorry driver that loses their driving license. And if we don't have alternative work for them, we can't employ them. And there's also a very broad category called some other substantial reason. So if he doesn't fit in the others, then maybe it's that one, and redundancy as well. So the employee can end employment, there can be mutual agreement, or the employer can end employment. And also, if you fail to renew a fixed term contractor on an employed fixed term contract on the same terms and conditions, and they've got 2 or more years service, then that potentially can be a dismissal situation as well. So a few different ways that termination ends. The last one, of course, which I shouldn't forget, but it's very rare, is a frustration that causes the end of a contract. And a frustration is an event that wasn't foreseen and is completely unexpected, and it means the contract cannot be the parties cannot work the contract. So if someone were imprisoned for 10 years, that would be a frustrating event, understatement, but that would be an event of frustration of contract. So yeah, if there's a dismissal by the employer, they have to identify which of the 5 potentially fair reasons is the dismissal under. And depending on which one of those 5, there has to be a fair process followed. So if you're going to dismiss someone because of their sickness absence, then you would want to have proper medical evidence about their long-term prognosis and when they might be well enough to return. You'd want to, if they had a disability, to have exhausted options on reasonable adjustments. You'd wanted to have had consulted and met with the employee to discuss that risk. You know, there's lots of steps that you would take. If you were wanting to dismiss someone for underperformance, you would follow your poor performance process or capability process. So have they had proper warning? Have they been given support? Have they been through the stages, you know, first, final, you know, written warnings? Have we lent appropriate support and training to enable that person to perform? Have we looked as the last step as to whether there's another job that they would be able to do if they're not able to perform in this job? And it's the same with conduct dismissals. Have we followed our disciplinary process? And so on. And redundancy is another type of dismissal, and that has obviously very specific steps in order to manage a redundancy, which I'll talk about in a bit more detail in a minute. So first of all, if it's not a resignation or a mutual termination, on what grounds do we think we should dismiss this person? And once we've picked which one of the 5 is applicable, what is the right process to follow in order for that to be a fair dismissal? And it's very important that we have substantive fairness and procedural fairness. And it's substantively fair if the issue is sufficient enough to cause someone to, at that point, lose their job. So, you know, if it's a gross misconduct issue, we had an example with Mr. Hope, didn't we? Raising all these grievances, not allowing the company to determine them, you know, repeatedly raising the same kind of grievance. You know, they determined that the act of gross misconduct, the substantive issue, was the destruction of the relationship now. And then they've got to tick the procedural box. Did they follow a fair process? Well, you know, I went through all the steps they took to try and determine the grievance. Then they followed their disciplinary procedure, allowed an appeal, and so on. So we've got to look substantively and procedurally to make sure that we fairly dismiss people. And people can only bring claims to a tribunal of unfair dismissal if they have 2 or more years service. So within 2 years, that protection does not apply. But I think you should still follow a good process. I think it's fair. And I think it also is appropriate for other employees that you employ to see that you would treat people fairly. There is a concept called automatic unfair dismissal, and that's where you don't need 2 years service if your dismissal is on the grounds of discrimination, or because you've taken paternity leave, or you know, bereavement leave, or if you've raised health and safety concerns, or you know, if you've raised a whistleblowing complaint. So there's lots of things where the 2 years isn't required. So it's never good just to look at how long someone's service is and make a decision, you know, we have no risk here, they don't have 2 years service, because there could be lots of other factors in play. So need to tread a little bit carefully. For a redundancy to be fair, you've got to demonstrate, firstly, that there is a genuine redundancy situation. If I had £1 for every client that's called me and said, oh, we need to get rid of this person, can we not just make them redundant? There has to be a genuine redundancy. You can't make someone redundant and then quickly re-employ someone to do the same job. So there would have to be a business closure. Either that's the entire business or a workplace closure. So a site or an office or a part of the organisation, or a reduction in the number of people required to carry out a specific type of work. You know, so we used to need 10 salespeople, we now only need 7. You know, there's a genuine redundancy situation there. And then there's steps for fair redundancy process, you know, proper warning that redundancies are coming. Think about, is there a collective consultation issue here? Because that's very legislative heavy. Collective redundancies are where there's 20 or more people proposed to be redundant within a 90-day period at a single establishment. So if you're in the larger numbers, then you have to follow the collective consultation process, elect representatives, go through proper consultation meetings, and so on. So early warning, check if collective redundancy is a situation. Have we got proper basis of how we're going to pool people at risk of redundancy? What selection criteria we're going to have? How we're going to apply that criteria? So how do we objectively determine who should stay and who should go? Are we looking at internal alternative vacancies because our obligation is to re-employ if we can? What about the financial aspects? Are we going to give the right of an appeal? The law doesn't require you to do one, but I think it's very sensible to do an appeal because you want to know if people have complained or not. Selection criteria has to be objective where possible and measurable. You know, stay clear of length of service, sickness history, all of those connect people to potentially discriminatory concerns, you know, age, if you look at length of service, disability, if you look at sickness and absence. So stick to standards of performance, you know, review ratings or appraisal ratings, skills assessments, qualifications, disciplinary action, you know, record. Have a matrix of criteria that you assess each person against so you can make really objective and defendable decisions. And then the right redundancy. If you're going to pay enhanced redundancy, I would always ask people to sign a settlement agreement in order to get the additional payment. That way, you know, a settlement agreement completely closes off any chance of any litigation or action at the employment tribunal. So either you have the statutory redundancy payment or you can have our greater you know, company redundancy payment, but you need to sign the settlement agreement to access that. So lots of things to think about with redundancy. Again, gov.uk, ACAS set out very simple redundancy processes to follow. Important one is to check whether you're in a collective situation or not. Okay, excuse me. So here's a question. What is the last day of employment if you pay in lieu of notice? And does that impact the redundancy pay calculation? Not sure if I set this as a poll or not. I don't think I did. So maybe it's just a rhetorical question. So the last day of employment, if you pay in lieu of notice, is that you bring back the last day to when they stop working for you. So pay in lieu of notice is exactly as it says on the tin. You pay instead of the person working the notice. So I think that's relatively straightforward. But does it impact redundancy pay? And the answer is potentially yes, it can, because under the Employment Rights Act of 1996, an employee's length of service is obviously critical in the calculation of redundancy. And the legislation sets out a relevant date where you calculate redundancy. And if you pay in lieu of notice, the relevant date is whatever date that person would have been employed if you add statutory notice onto their end of employment date. So if someone has 2 or more years service, statutory notice is 2 weeks. And if they have 12 or more weeks notice, it goes up a week for every year. Statutory notice is 12 weeks. So you add on to the end date whatever number of weeks is appropriate. And that, of course, could take that person into a different age category in the redundancy calculation or give them more years of service. So paying in lieu of notice does impact redundancy pay because you have to add on this statutory notice to get what would be the relevant termination date. Good. I think this is the last thing I'm going to mention on this section, which is settlement agreements and COP3s. I've mentioned what settlement agreements are to you already. This is a way you can have an agreement that if the employee or ex-employee signs along with their solicitor, legal advisor, then they can't go to a tribunal. So it's a really important document if you want to be clear that no further action is going to happen. You can also use ACAS for a free service, which is called a COP3 document, which does the same thing. So if you want to access either of those for, to be really clear about whether or not there's more issues to follow or whether you're likely to have a claim, then they're good things to pursue. So watch out for that. Okay, we're into our last section, which is about what's on its way. So what do we expect to see in the future? Now, we did 9 and 10 earlier. I'm going to run you through 1 to 8 super quickly because that's most of what we've got to come. So the first thing is the Protection from Redundancy, Pregnancy and Family Leave Act of 2023. So this legislation will give greater protection from being made redundant for someone during their pregnancy and for new parents. So the current guidance is that there is some protection for people already, but this is going to extend redundancy protection. So under the new law, the period of protection from redundancy will be extended to protect expectant employees from the moment they inform their employer of their pregnancy up until 18 months. So if a woman takes the maximum maternity leave of 52 weeks, she will get an extra 6 months protection after she returned to work at that 52-week point, for example. And the new law is also going to extend the kind of priority status to people in terms of getting alternative employment when they're at risk of redundancy, and if they've recently suffered a miscarriage or returned from shared parental leave, adoption leave, as well as maternity leave. So we're expecting to see this legislation at the April 2024 stage, and it will be very clear then exactly what this will look like. Redundancy, of course, will still be a potentially fair reason to dismiss an employee. However, if you're going to dismiss an employee that's captured by this redundancy and family leave legislation, you would need to have been looked at what that protection is and ensured that you haven't treated someone less favourably, that there is a priority status for those people under this legislation. Okay, so that one will be coming in and we'll get more detail exactly what the date will be next year and what the rules will look like. And then we've got Neonatal Care Leave and Pay Act. So this is where all employed parents will be entitled to up to 12 weeks of neonatal leave if their baby receives neonatal care for a week or more. The baby has to be newborn, so up to 28 days old, has to have been admitted to hospital, and has to have been having a continuous stay in hospital of 7 full days or more. So again, lots of specific issues in this neonatal care leave and pay legislation. We need to know how many weeks service an employee would have to have, how they would make that claim. And I saw actually recently that Tesco's has introduced lots of new rights for family-friendly policies and introduced something called the kinship leave for employees responsible for caring for relatives' children. I mean, that's not a legislative issue. That's obviously something they've decided to do. But, we will have this neonatal care and leave for that specific scenario where it's a newborn child requiring hospitalisation of 7 days or more. Okay, carers leave and pay. This received royal assent on the 24th of May 2023. So again, we're expecting this to come in April. It will be a day one right, so no minimum service required. It will consist of 1 week or 5 working days of unpaid leave for employees who have long-term caring responsibilities to take that time off in either full days or half days. And again, there'll be rules about notification for this leave, in what circumstances, whether it's self-certification or not. I don't think there'll be any evidence requirements, but it's unpaid. So, it may or may not prove to be one that people are interested in, but nevertheless, this will come into law at some point early next year. I mean, some of these, as I've said, the indication is April for these, but we'll have obviously more detail shortly on them. I just thought I'd put up a slide just to remind you of all the other types of family-friendly leave we already currently have. And I think it's good to have a policy on all of these, so you're clear what the right is, what the service is, what the notice is to request it, how an employer would manage each of these processes. So I'm not going to go through them with you because we definitely don't have time to do that, maybe for another time. But I just wanted it to be a reminder that those three that I've just mentioned to you, we're adding on to these already. Okay, then we've got the TIP legislation. This has been definitely long awaited. It's been floating around for a long time. And this is now expected finally to come into force in April next year, or it could be May. The government said years ago that they would only bring in new legislation in April and October each year. So we'll wait and see. But this act creates a legal obligation for employers to allocate qualifying tips, gratuity and service charges fairly between its employees. And once it's in, then there'll be this legal obligation for employers to have a written policy to set out how it's going to allocate qualifying tips amongst its employees. It will have to keep and share, if requested, records of what qualifying tips were received and how it's been allocated. So yeah, this will be definitely the long-awaited tip allocation legislation. My youngest son worked at, I won't say where, but a few restaurants as part of being at school, to subsidise his income, and he was most upset that only cash tips were ever distributed and never card tips. But there you go, too late to benefit from that one. Then we've got the Employment Relations Flexible Working Act of 2023. So I would imagine you're all pretty familiar with the flexible working legislation anyway. It's been around a while, we're pretty used to it. And this is going to enhance the rights for employees to request flexible working arrangements. So a bit like that redundancy one we looked at first is an enhancement of an existing right, and so is this one. So this will bring in a number of changes, and I've put them up on this slide. So employees are likely to have a day one right to request flexible working. At the moment, employees have to have 6 months service to request flexible working. And secondly, employees will be able to make 2 flexible working requests in any 12-month period, whereas currently they can only make 1. Employers will be required to deal with requests within 2 months of the request being made, not 3 months, which is the current position. So that will speed that up a little bit. Unless an extension is agreed. Employees will not have to explain within their application the effect that acceptance of their request might have on the business, or how any effect could be minimised. So that'll be a matter for the employer, not the employee, which reverses that current position. And then employers will be required to consult with employees before they are able to refuse a request. However, there's no clarification on what constitutes sufficient consultation. I kind of think this one should be happening already in any event. The reasons to turn someone down aren't changing. Importantly, this legislation doesn't create an automatic right to give flexible working. So it's not a change in that respect. But the reasons that an employer might turn someone down have not altered, they're just the same. And I think employers need to be careful when they turn people down. because it's easy to have an assumption. It's easy to say, for example, oh, people can't be recruited to do the work on the day you don't want to work. So if somebody wants to work, you know, Monday to Wednesday and not work Thursday or Friday, an employer might say, well, it's going to be very difficult to find someone that just wants to work on Thursday and a Friday. But there's a big difference between it's going to be very difficult and people, you know, we cannot recruit people to do that work on those days. So I would expect an employer to have had, you know, to have put out an advertisement to see if they can job share a role, rather than just say, oh, it's going to be hard to find someone. So there is some sort of, you know, it's flexible working requests with some teeth, if you like. And there's lots of flexible working case law all the time. So we need to think about that carefully when those changes come in again next year. Then we've got another bit of trade union legislation. This is the Strikes Minimum Service Levels Act of 2023. So that too has gained royal assent, having passed through the parliamentary process. So government ministers now have new powers to restrict the impact of strikes in certain public services. So the aim of this legislation is to impose minimum levels of service provision during industrial action, and that's going to affect, you know, ambulance staff or firefighters, of course the railway workers, you know, those in sectors that are deemed essential, basically. And so the government's going to proceed now with plans of how to implement minimum service level agreements for, you know, let's take rail services for an example. And there'll be consultation on the most appropriate approach for delivering minimum service levels and so on. So a little way to go before we see what that actually means. But this has not been very welcomed by the trade union movement either, as I expect you would appreciate. So it's therefore possible that the Act won't have massive practical effects, but, you know, let's wait and see. But that's definitely come into our legislation now. And then we've got the Worker Protection Amendment of Equality Act of 2010 bill. So it's still in its final stages. This bill originally put an obligation on employers to do two key things. One is to prevent harassment by third parties during the course of employment. And secondly, that employers must take all reasonable steps to prevent sexual harassment at work. So it's specific to sexual harassment. However, in its process through the House of Commons and the House of Lords recently voted to remove point 1 completely. So there is no prevention of harassment by third parties. And they've also downgraded the second part of it to say that an employer must take reasonable steps instead of all reasonable steps. And where an employer has failed to take reasonable steps, then the tribunal may uplift a compensatory award by a further 25%. And the bill also has a new express duty on employers to prevent sexual harassment of employees. So I talked to you already about, you know, that vicarious liability point, where if employers want to escape liability for discrimination complaints, they have to show they've taken all reasonable steps to eliminate discrimination. Well, under this legislation, there will be an express duty on employers to prevent sexual harassment specifically. But there we go, it's still in its final stages. So we've already seen some major change to it. I'm not sure there'll be too much more, but we'll wait and see. The next one is the Worker Predictable Terms and Conditions Act of 2023. So at the end of September, this got royal assent, and the Act will give workers and agency workers the right twice a year to request a predictable work pattern if their current work pattern is unpredictable. And their contract has to be for 12 months or less for an unpredictable number of hours or days of the weeks or times. So the regulations will set out what qualifying period would make someone eligible to make a request, which we expect to be 26 weeks. And it's all about getting more predictable working for those with unpredictable working patterns. So again, the government expects the new rights to come into force next year. We don't know whether it'll be early or later. ACAS has said that they will draft and consult on a new statutory code of practice to provide guidance on how requests should be made and considered and responded to. So this is more for employers, again, with atypical workers to put in place appropriate policies, practices and procedures. So really we need to wait for the statutory code to see how this is going to work in practice. But that one has been passed. Then we've got the Economic Crime and Corporate Transparency Bill. So you might be aware that there are already a number of workforce crimes on the statute books already. For example, in redundancy, if an employer fails to lodge a completed, it's called an HR1 form, which is basically the form the government require employers to complete when they're going to make more than 20 people redundant at a workplace. So if an employer fails to complete that form, then that's a criminal offence. Employers also have a criminal offence with lots of health and safety issues. So there's lots of criminal offences within the health and safety legislation. But this will be another one to add to the potential criminal liability area. And it will be called the failure to prevent fraud. And fraud is the most common criminal offence in the UK. It counts for 41% of all crime, according to stats up to September 2022. So I guess it's no surprise the government is clamping down on dishonest practices by ramping up criminal liability for organisations whose employees or agents commit fraud for organisational benefit. So the new offence will be called a failure to prevent fraud offence, similar to the offence of failing to prevent bribery. So there's lots of similarities there. So I won't go into any more detail because it's not entirely an employment matter, but obviously it relates to employees, and it will be something that we'll have to bring into, if applicable, bring into and up to employee notice and standards and so on. And I'm sure it will result in more policy. The only organisations covered by this new offence will be those that are deemed large. So more than 250 employees and certain amount of turnover and so on. Okay, good. Then this is an interesting one. So at the moment, there's nothing, the word bullying is not mentioned in any of our legislation. So there's a private members bill called the Bullying and Respect at Work Private Members Bill, which proposes legislation that would introduce a statutory definition of bullying for the first time to enable people to claim workplace bullying at the employment tribunal. So something that you can't do at the moment. At the moment, you can bring a harassment claim, and harassment, as we looked at earlier, is defined in the Equality Act as something that relates to a protected characteristic, whereas bullying has nothing to do with the protected characteristics. So that's why most policies are called bullying and harassment, because harassment is very specifically about, I've been treated that way because I'm male, old, disabled, whatever it might be. Whereas bullying has nothing to do with your protected characteristic. It's all about how you're treated, the behaviours. So at the moment, if an employee thinks they've been bullied out of their job, they're left with an unfair dismissal complaint and nothing else, or breach of contract as well if they leave without giving notice, for example. So this bill supports a new statutory definition of bullying, a new distinct claim of workplace bullying that a tribunal can hear, and a Respect at Work code of practice that would set out minimum standards for what positive and professional and respectful work environments look like. And it's to give powers to the Equality and Human Rights Commission to investigate workplaces and organisations where there's evidence of a culture of bullying or where there's a number of incidents, just the same as they can where, if there's discrimination. So it'll be interesting if this goes any further. At the moment, it doesn't even have government backing. So, you know, who knows? But I think it's a really interesting one because, you know, there's no way at the tribunal other than for someone to have left their job and claimed constructive dismissal, or if they've been dismissed, for them to bring a complaint that relates to workplace bullying when it's not related to a protected characteristic. Okay, then we've got paternity leave. So there's been another recent government consultation looking at whether we need to amend the current rules on paternity leave. And that includes flexibility as to when and how someone can take paternity leave. So at the moment, a person is entitled to a single week or 2 consecutive weeks to be taken within 56 days of a baby's birth or adoption placement. And what the consultation is going to say is, should it be either 2 separate blocks of a week, you know, rather than you have to take them together, and should it be over a longer period? So should you be able to take it over 52 weeks rather than just in that first 8 weeks or 56 days? And also it proposes changes to the notice period to be given. And the government has said that these changes will be implemented in due course, but I can't see any way they're going to be caught up in the changes that we think likely for April 2024. But they seem quite sensible tweaks to me. Don't mistake paternity ever for paternity leave, which I see more and more of, people introducing pet-related leave. There's quite a number of employers with paternity leave. I've got one client in particular where every time I visit them, there's a whole range of dogs, mostly, wandering around their office, but that's nothing to do with that, and there's no legislation about that either. Then I want to mention very quickly about restrictive covenants, because a lot of contracts include some sort of restriction post-termination as something that people are contractually bound to abide by. And the UK government has announced its intention to limit the duration of non-compete post-termination restrictive clauses in employment contracts to a maximum of 3 months. And I've seen some that are up to 12 months in terms of restriction. So that's the consultation, is that there should never be a restrictive covenant or clause that's more than 3 months. And I'm sure you're familiar with non-compete clauses, and the purpose is to protect a business, but not to restrict a former employee from finding employment. So it's a fine line, that one. It'll be interesting to see what happens as a result of that consultation. But that's the proposal, to restrict that to 3 months. Okay, and then in the biggest shake-up, I think, of civil penalties for a long time, the government has announced, and this was only recently on the 7th of August, that fines for employing illegal workers will be tripled. So, as I mentioned earlier, all UK employers must conduct a right-to-work check on every individual they hire in order to prevent illegal working. So it should be on every individual you do the right-to-work check. And they're really simple to carry out. And if you're unsure of what it is, again, .gov.uk right-to-work checks will set out exactly what you need to do. The current fines are £15,000 for a first breach, if you're caught employing an illegal worker, and £20,000 for a repeated breach, and that's going up to a fine of £45,000 for a first breach, £60,000 for repeated breach. And again, these will come into effect in 2024. I haven't been given a date yet, or I don't think there's a date yet, but it's on its way. So at some point we'll get the date for that. Okay, and then I thought I would just tell you what Labour has planned for us before we finish. So Labour Party set out their proposals some time ago. I think the next general election is due early 2025. So this isn't imminent, of course, but current prediction is that they'll storm through the polls, but, you know, we'll wait and see. But the Labour Party set out their employment rights green paper a while back and has a whole host of new employment law that they will bring in the first 100 days. Should they take over. And proposals include scrapping the 2-year qualifying period to bring a claim of unfair dismissal, which would be an absolutely massive change. As I said earlier, for the first 2 years, people don't have unfair dismissal protection rights. They have other rights, but not that one. So taking that away would be a big change. It did used to be 1 year a while back, but it's been 2 years for some time now. They've also said they'll extend the time limit people have to bring a claim to the Employment Tribunal. At the moment, for most claims, you have to bring your claim within 3 months of whatever you're claiming about. So if you're dismissed, you have to bring your claim you go via ACAS first, but you have to bring that claim within 3 months of the date of dismissal. So 3 months minus a day. So they're talking about extending that to give people more time. They're talking about banning 0 hours contracts entirely, reversing and strengthening the rights of trade unions. I guess you're not surprised to see that one there, and lots of other changes. So I just thought I'd shine a light just in case in the future that's one that we have to look at. Right, I've got just enough time, hopefully, to pick up any other questions. So let me just pop across to the questions. Right, flexible working. If an employee knows that their working pattern will change twice in the space of the year, can they make both requests in one flexible working request, or can only one be accepted? So this, I think, relates to the new extension to flexible working legislation. I think you would need to make your flexible working request. If you can make 2 and you know that there's 2 changes, I think maybe you can do either. I'm guessing slightly because we haven't seen the exact detail or the guidelines to the new legislation, but you could certainly, you've got the option to request a change of flexible working twice. Whether you would want to stop the next change happening by requesting that it doesn't happen in your first request might be a possibility. So I'm not entirely sure, to be perfectly honest, but at least you will have the 2 options either way. So hopefully that answers that question. Absence during probation. We've got quite a few new staff who go absent without leave whilst on probation. I'm currently following the disciplinary process for anyone that goes radio silent, but I've also seen in some contracts, online sources, that the proper disciplinary process doesn't apply during probation. Would it be good practice to continue with the disciplinary process, or keep the process simple by advising managers to consider failing probations without inviting to hearings? Okay, so probationary periods, great thing to have. Sometimes some employers say that there will be limited process applicable to people on probation periods when it comes to disciplinary, which I think is fine. For me, when someone doesn't turn up to work, when they're absent without leave, and you attempt to contact them and you have no contact, I would immediately write to that person, or, you know, in whatever form you've got, text, you know, letter, email, and ask them to contact you immediately. And they're absent without authorization, and therefore their pay has been stopped. That normally prompts people to get in touch, because you don't have to pay someone who hasn't turned up for work. And if you still don't, and give them a limited amount of time to do that. If you still have no response, you know, as in your case, still radio silence and they've not come to work, then I would write to them and say that a disciplinary hearing will be held on X date at Y time and they're invited to attend. However, if they don't attend, it will be held in their absence. The reason I wouldn't just jump to let's terminate their employment is because something awful might have happened, and rather than unpick an issue, it's easier probably to do it the other way. If you stop their pay, the issue of cost kind of immediately stops. I know it's still really frustrating that you haven't got that person at work, but, you know, I think I would take that extra step. It's not much difficulty, just so, you know, procedurally you're as fair as you can be. So I think that's what I would propose. And then there's one more regarding the right to work checks. What if you have unintentionally not done the right to work checks and they have already started employment for you? Can there be problems for not only the company, but also for the HR person doing the checks? And then it says, hope the question makes sense, and it does. So if you haven't done the right to work checks correctly, I would go back and do them ASAP. So at least you've covered off that issue. Then the next point is, can there be problems not only for the company, but also for the HR person? No, I think the employer this is where they're caught with vicarious liability. They're responsible for what that person has or hasn't done. I mean, there might be disciplinary responses for that HR person, but no, I don't think they are personally accountable. I'm saying I don't think. I would, to be absolutely sure, I would need to check that one. But that's interesting. I think if you know it's happened, just go back and do the right to work checks now. They're not that difficult to do. Thank you. And then I've got one more. A client is currently facing live in-ground, a question that a client is currently facing, sorry. So they have live-in ground caretaker with rent-free accommodation provided. However, shortly, 2 of the caretaker's 3 children are reaching the age of 10, and as a result, the accommodation provided will become overcrowded. The caretaker is requesting alternative accommodation, but the employer is unable to provide it. The employer is now considering dismissing the caretaker. Should the employer first seek to come to an agreement with the caretaker for him to leave the accommodation, or seek to terminate the contract immediately? Well, this is a super complex area because you've got 2 different things going on here with someone having accommodation. I can't give you any advice on that on this webinar. That client needs to take some very careful advice, because those are 2 very separate things. Dismissing someone because they've outgrown their accommodation would have to fall within one of those 5 potentially fair reasons for dismissal, but you've still got, you don't want to be in the position where you've terminated someone's employment and they've stayed on in the accommodation. So I think that's probably too big an issue to look at on this webinar, but very carefully managing both of those things in parallel is absolutely essential. Good. Okay. And I see you've just answered. Thank you. Right. So lovely. We've come to the end. The very last thing I was going to do was just give you a very quick update on where we are at the Employment Tribunal Service at the moment. So this isn't a poll. I'm just going to tell you. What's the average number of weeks it takes to get a claim heard in the tribunal system at the moment? And the answer is at least 49 weeks. So that's from date claim is brought to date of hearing. So nigh on a year. Question 2, how many cases were raised in the last year that we have stats for? And the answer is 118,000 approximately. Are the number of cases brought in a year higher or lower than they were 10 years ago? Well, they're actually lower, and they are substantially lower, over 100,000 cases lower than 10 years ago. How many cases are currently outstanding? So how many have we got to deal with in the tribunal, let alone the new ones coming in? And there's a backlog of at least 50,000 cases, totally swamped. Most common claim is unfair dismissal at the moment. A most common discrimination claim, it's age at the moment, but normally it's sex. What percentage of claims are settled? 24% of claims are settled. And then finally, of those determined by an employment tribunal, of what percentage does the claimant win? And the claimant wins on average 61% of the time. And that's based on the last set of stats. And that brings us to the end of our 3-hour webinar. Thank you so much for all your questions. Thank you for doing the polls. I hope that's been a kind of good update or a reminder of some of those key 4 areas we decided to go through. And I hope you have a great day and a lovely weekend. So thank you very much.